idea or issue. When we get it, we freak out. Oh my God, is this an ICWA case? What am I supposed to do? It's really not that difficult if we can just follow some simple rules. And to start off the training, given that this is an elimination of bias training, I'm going to take you guys through a little bit of a cultural and historical background to help you maybe appreciate and understand why ICWA seems so difficult in Los Angeles County in particular, why we have these cases where it seems like, I don't know, sometimes 50% or more of our clients are like, yeah, I think I have Indian ancestry, but then it turns out to be nothing after all. So to begin with, I'm also going to sit down if that's okay. To begin with, for the first slide, I know you guys got very small little printouts, so I made a couple little extra copies of the picture of the boarding school for people to pass around in case anybody is interested. If you can like pass around for people to look at. ICWA was really created for a very important reason, and a very important reason that still exists today. There's been actually very recently an NPR study, I believe in South Dakota, that indicated that the rates of Indian children removal from their homes are still exorbitantly high compared to the rates of removal of other children. In LA County, it only parallels the levels of African American children. The real background to this is a lot of really bad stuff happened to Indian people that really led up to the ultimate creation of the Indian Child Welfare Act. General Sheridan back in the day is quoted as having said, "The only good Indian is a dead Indian." Started with, in California, the missions in the early 18th and 19th centuries, where Native American people were essentially forced to become civilized white men. They were used for indentured servitude, slave labor, and they were trained to learn the Christian ways of life. Then the first legislator of California authorized by law indentured servitude for Native American people and issued false promises for land and opportunity for Native Americans who would come to California or be a part of this program. Then it furthermore got compounded with government-sanctioned forced relocation and tribal termination programs throughout the entire nation. In 1953, there was a resolution which was essentially the reservation termination program, a resolution through the House that ended up with more than 100 tribes being terminated through that program. Many of those tribes were able to reinstate their tribal status, but over 13,000 Native American individuals lost their tribal affiliation through that termination program. And then you have the Indian Relocation Act of 1956. That's where LA County really starts to become impacted by this in particular. The Indian Relocation Act of 1956 gave promises to Native American people to leave their reservations to come to urban centers such as Los Angeles, Chicago, New York, for a promise of land, jobs, and opportunity. I bet you all can guess that didn't work out very well for them. The jobs went away. The land wasn't actually given to them. These Indian people were then found separated from their tribal culture, from their tribal community, from their, some of them from their reservations. Not all tribes have reservations, just fun factoid. From their reservations, and started to lose bits of their culture, bits of their understanding and appreciation of their history, because they were taken away from that. The first picture that I showed you, that hopefully everybody's getting a chance to maybe take a brief look at, is an example of the Indian boarding schools that were put into place. That one is from Carlisle Indian School, and that picture is from around 1900, which I know significantly predates the Indian Child Welfare Act. However, it gives you some background and understanding. These children were removed from their parents, placed in boarding schools where they were taught to be white, where they were, the Indian was taught out of them. The slogan oftentimes was, "Kill the Indian, save the man." not literally kill the Indian, but the spirit and culture of the Indian. These children were stripped of their clothing, their hair was cut. You'll find in a lot of Native American cases, if you do have Indian cases, the hair can be a very important thing for them. Not all tribes and not all individuals, but long hair can be a symbol and an important thing to their culture depending on the tribe. These children were sent into these boarding schools where they basically were all given what appears to be some kind of horrible bowl cut. And awful baggy uniforms. So, and then the children were taught away from their language, they were taught away from their culture, and they were sent back to their parents, sometimes, not always, with no understanding or appreciation. So that is what all leads up to the problem that we have in trying to identify what is really an Indian case in Los Angeles County. The urban Indian population in California is one of the largest in the entire United States. California, according to the 2010 census, although we're coming up on 2020, so we'll see, had the largest Indian population of any state. And I gave you some of the numbers for who identified as AI/AN is American Indian / Alaskan Native. It's important to remember that we are not just looking at American Indian tribes. There are also Alaskan Native or Eskimo tribes that are groups that are included within the Indian Child Welfare Act. So I gave you some of the numbers for who identifies solely as American Indian or Alaskan Native and who identify as American Indian and Alaskan Native in combination with some other nationality, ethnicity, or race. And those numbers combined is the total number of Indian population in California according to the 2010 census. Over 50% of California's Indian population, those approximately 720,000 individuals, trace their ancestry to tribes outside of California. And this is due in large part to all those programs that I have just indicated to you that were put in place concerning urban migration and relocation. That means that our clients sometimes are a little bit separated from their identity, from their culture. That does not mean that they are not Native American or that they don't necessarily have a membership in a tribe. And I'll get to why there's a very important distinction between membership and registration. So we're going to have to be very careful about how we identify our clients as American Indian or Alaskan Native from the outset. And then I gave you some numbers about the number of federally recognized tribes in California and nationwide. The purpose of ICWA was finally in 1978 after the Indian policy review that found that Indian children were 840% more likely to be adopted than children of other ethnicities or races, and 270% more likely to be in foster care. Congress decided something needed to be done, and some minimal federal standards were put in place. That's the Indian Child Welfare Act. Those standards are intended to protect the best interests of Indian children. And also there's an important part to it, which is to promote the stability and security of Indian tribes. So the important part to remember is we have a client to represent, and our client is what's most important to us in any of these cases. But just note that there's always a separate interest, not one that we have to represent, but one that is an interest also in these cases of the tribes independent from our client's interest. There's only been 2 Supreme Court cases since 1978 dealing with the ICWA. There was almost a third, if anybody knows the Save Lexi saga, but the Supreme Court denied review in that case, thank goodness. These 2 cases, not really, I would say if you ever find yourself with an ICWA case or find yourself with, probably the circumstance would be a de facto parent trying to fight against Indian preferred placement. I would argue that neither of these really apply super strong to our cases. Both of these involve voluntary relinquishments. Mississippi Band of Choctaw, what it really stands for, I think, in any of our cases is that the placement preference portion of the Indian Child Welfare Act is the most important portion, they've always said, because the standards about removal and otherwise, there are state laws that protect from removal of children from their parents. What's most important is making sure that even in the case of a removal, children can remain with their family, with their culture, with their community. That's kind of what the Mississippi Band of Choctaw Indians versus Holyfield case stands for, but it was a case of voluntary relinquishment and dealing with some exclusive jurisdiction issues with parents giving birth on the reservation and taking the child off for adoption. And in that case, the parents actually were the ones who were trying to have their child adopted by a non-Indian couple, and the court applied the Indian Child Welfare Act. So just an interesting piece of information. And then adoptive couple versus baby girl, I think there's dicta in that case that specifically says that in a dependency case, it would be very different. So, and I have had the experience of de facto parents or foster parents trying to bring up that case to talk about the issues of placement preferences and to talk about paternity, because in that case, they the father was objecting to the termination of his parental rights. There's some dispute over whether or not he had proper notice, voluntarily relinquished his rights or not. But at the end of the day, he said, no, I don't want to give up my rights. I want my daughter. However, under the state laws that applied to this case, under any of the state laws that could have applied, either I believe it was Carolina or Oklahoma, he was not a legal father. We have different rules in California, so I think that this case arguably does not apply to our cases because of the dicta about dependency cases and because of our different standards for determining who is a father in a case or not, and because, as I'll get to, the fact that California has established stronger and stricter standards for the protection of Native American or Alaskan Native individuals through our Welfare and Institutions Code. As I said before, these are minimum federal standards through the ICWA. The ICWA says that where the laws are different, the higher protections apply. So if state law is more protective, then the state law applies over federal law. If federal law happens to be more protective, then it preempts the state law. So just keep that in mind. The next picture is just sort of a little example for you guys about being aware and cognizant of the fact that it's impossible to identify an Native American individual by simply looking at them. And I just thought this was an interesting comment because I certainly have, in a number of cases, experienced this sort of animus or bias towards an individual who doesn't look Indian. I mean, some of the statements that have been made in cases reflect foster parents saying, well, this child just fits right into our family. She looks just like us. I mean, look at these pictures. She doesn't look like an Indian. I mean, those are the things that were being said to thwart a relative placement and to indicate that an Indian child should not be treated as an Indian child and had no right to her family and culture. Unfortunately, my next slide is not going to have quite the impact that I hoped for it to have, but just imagine it in blue scale, okay? Pretend like those are all different shades of blue. And it was really going to be an exercise in sort of adding some humor to this and just letting you guys know an experience that I had in a case. I was going to ask you if anybody could tell me which color was Navajo blue on this spectrum of colors. And the problem with that is there is no such color as Navajo blue that I can find anywhere. However, in one of the most recent high-profile ICWA cases that I was a part of, it has now come out in the published opinions of that case that the de facto parents, foster parents, of the child who were fighting the placement with relatives under oath and testimony indicated that the way that they intended to incorporate culture into this child's life among some minimal other things, was that they had painted a wall in their kitchen Navajo Blue. I saw that wall on NBC when they gave an interview in their kitchen, and it certainly just looked like a bland teal to me. I don't know what they think Navajo Blue is or what the significance to them is that, and by the way, this child that, in the case that I'm referencing, is a Choctaw Indian child. So even more so proves the point that, there's just this lack of understanding and appreciation of the various and vast differences that can be found within tribal cultures from tribe to tribe, and this sort of idea that maybe there's like tokens that can be given or little items that can just represent an entire community or culture. It's something much more than that. What we were fighting for in that case, and what has ultimately happened, was having this child live a life with her relatives, live a life immersed in the culture, having the experience to hear stories about her great-grandmother who was an Indian chief, to hear stories about her other relatives, to learn about the Trail of Tears that her ancestors had been through. Those sorts of things that you can't get from painting a wall blue or buying a child an Indian doll or a dream catcher and putting it up on the wall. Those things just don't really give a person the identity that they need. And there's a lot of studies that talk about this. And if anybody is more interested in that, I'm happy to direct you appropriately. But there's like split feather studies, the split feather syndrome study, and a lot of other studies that talk about how really significant the effect of this misidentity or lack of identification that this can have on American Indian people. So now to the practical portion of the training that I'm sure you guys are all waiting for. What is an Indian child? An Indian child, so I started with 25 CFR 23.2. I want you all to know that I know I gave a training on ICWA, 2 parts, about 3-ish years ago in 2013. Since then, there have been subsequent very substantive changes to the law, including some amendments to the rules of court, recent publication of the new Code of Federal Regulations. That's 25 CFR 23 et al., and I'll be referencing it throughout the materials. But that was made effective December 12th of this past year. So all of this is very up-to-date and relevant information for you, and I would probably disregard most of anything that I said in my last training. I mean, it mostly applies, but this is more accurate. So an Indian child is an unmarried person under the age of 18. Slight caveat, Welfare and Institutions Code 224.3b has been amended to allow for non-minor dependents 18 to 21 to be identified as Indian children so long as they want to be identified as an Indian child. Not really a problem for us because we don't deal with non-minor dependents, but didn't want you to be completely out of the know. For our purposes, an unmarried person under 18 years of age who is either a member of a federally recognized Indian tribe, and I've given you the link to, and I will send this out, by the way, in electronic form because I've included a lot of links throughout. So I'll send it out in electronic form so that you guys don't have to type out all the various links if you need the information. But I've given you the link to the list of federally recognized tribes that was updated as of May of last year. That list is alphabetical and contains every tribe that has been given federal recognition at this time. It's very important that, I mean, I have found sometimes that our clients don't really know how to spell the tribe's name. They don't really know exactly what the tribe is. I have found that Google, I know it sounds weird, but Google is kind of my best friend in that situation. A quick Google search of like something that sounds like, I actually think I did one for one in the courtroom the other day, and I found a couple of different options that could be the federally recognized tribe that this individual was suggesting. They had spelled one letter wrong. It was like an H after the A instead of before the A. And I think sometimes, even though that's not necessarily our duty, it is imperative on us to try and help our clients, especially if they do think that they have they do honestly believe that they have some Native American heritage. It's important to try and figure out what tribe they actually trace their lineage to determine if they are a member or eligible, or the child is eligible for membership. So that is the list of tribes. Feel free to look at it if your client suggests a tribe, but also don't be afraid to do a Google search or indicate on the form that spelling is uncertain. Because what you don't want is them to say, well, we looked up blah-de-blah tribe and there's no such thing, so I guess we don't need to notice. So I'm a member of a federally recognized tribe or eligible for membership in a tribe and is the biological child of a tribal member. So our clients have to be members of the tribe, and the child must be eligible in order for them to be an Indian child, unless the child themselves is registered in the tribe. So what you're really wondering is if your client is a member of the tribe. They may not know that they are a member of the tribe. They may say, well, no, I didn't register. I didn't do anything. Registration is not membership. Not every tribe requires registration. Not every tribe requires enrollment. I've given you a citation to DBV Superior Court, which essentially stands for enrollment does not equal membership. You really still need to send out the notices if a client is identifying as potentially part of a tribe and doesn't know. Obviously, if your client walks into court with a registration, a verification of registration, or a membership card, then we have a completely different situation, and this is looking very much like an ICWA case. But don't just count out your clients because they're like, well, I don't know, I didn't know, I don't think I'm enrolled, or I don't know if I'm eligible, or I don't know if I'm a member. Because, as I explained to you, that entire first part with the history of trauma and the relocation and the separation from their family and culture has resulted in a lot of people not really knowing if they are part of the tribe or not. Some tribes simply give membership based on blood lineage, and so if they can trace their lineage to somebody who was on the Dawes roll, the registration of Native American persons, then they are a member of that tribe. Some tribes require them to actually file formal enrollment papers. So you don't know until you send out the notices. Important to know that there is no such thing as the existing Indian family doctrine anymore. That has been a big topic of dispute throughout the nation for some time. However, California was ahead of this trend. I believe in my last training, I had even indicated that it was not applicable in California. However, now the new federal rule makes it very clear that the court may not determine that ICWA does not apply to the case based on factors such as participation of the parents or the Indian child in tribal, cultural, social, religious, or political activities, the relationship between the Indian child and his or her Indian parents, whether the parent ever had custody of the child, or the Indian child's blood quantum. So there are some tribes that determine membership based on blood quantum. Navajo is one of them. However, that is not up for the court to determine. That is up for the tribes to determine. So it is important to know that while the courts can ask questions during their inquiry about, did the child ever attend an Indian school, receive Indian services, has anybody in your family lived on a reservation, those things can help to provide us with information about whether or not a child may be an Indian child. The court cannot exclusively determine that a case is not an Indian case where there is some indication just because the parents are, whereabouts unknown, or, if a grandma comes in and says, this child is Indian, they don't get to say, well, the parents aren't really around, so we don't need to apply that. Or, well, this child was detained at birth, so they didn't even really become an Indian child, did they? No, that's not how it works. It's a very strict statutory definition, and we need to go by the statutory definition. So when does ICWA apply once you determine who is an Indian child? ICWA has requirements that apply whenever an Indian child is the subject of a child custody proceeding. And this includes involuntary proceedings. Those are the proceedings we deal with. ICWA does not apply to an award of custody of the Indian child to one of the parents, including but not limited to an award in a divorce proceeding. So I pose that in juxtaposition with our California Rule of Court 5.480, which basically says that ICWA applies to most proceedings involving Indian children that may result in an involuntary foster care placement, guardianship, or termination of parental rights, and then goes on to say that it applies to proceedings under Welfare and Institutions Code Section 300. So I pose to you, what do we think? Does it apply to a child that remains released to one parent at detention, or a child who is placed with a parent at dispo? Does anybody have an opinion on that?
I'm going to go with no.
You're going to go with no?
Because that's not going to result in placement with foster care.
So I think the answer is